President Trump's signature economic policy is taking center stage at the Supreme Court today.
The future of his tariffs hangs in the balance. Justices heard oral arguments on the case today. At issue is a legal question around the limits of executive power. The court is deciding whether the president has the authority to impose sweeping tariffs on imports under a law that's meant to apply to national emergencies.
8 small businesses sued the Trump administration, arguing these tariffs hurt their bottom line. The plaintiffs include a wine and spirits importer, a sport fishing retailer, and a cycling apparel outfitter.
I think what's really at stake most of all is whether or not the president has violated the Constitution. Because, again, we have to go all the way back to the founding of our country. You know, no taxation without representation is on that license plate on everybody in the District of Columbia. And what it really is saying is the Constitution gives to the Congress, not to the president, the power to impose taxes or tariffs. The Constitution gives to the Congress, not to the president, the right to regulate foreign commerce. So the issue is, how is it that President Trump can now start to impose all of these tariffs, again, this huge increase in taxes on Americans, without the Congress?
A historic decision is imminent in the United States Supreme Court. It is one that will not just reshape American law, but will send an immediate and potentially devastating shockwave directly into the Canadian economy. This is not a story about a new trade deal or a sudden tariff announcement. The trigger for this crisis is a gavel in a courtroom over 1,000 kilometers away. The justices are set to rule on the legality of President Donald Trump's sweeping tariffs imposed under emergency powers. But for Canada, this legal battle creates a terrifying paradox. A victory for the rule of law in Washington could become the prelude to Canada's worst economic nightmare. This is the ultimate case study in asymmetric power, and to understand it, we must start not in Ottawa, but with the unlikely American and foreign plaintiffs who dared to sue their own government. The legal challenge to Trump's tariffs is not a single lawsuit. It is a multifaceted insurrection from within the U.S. system itself. The first and most visceral challenge came from the heart of American commerce. Rick Woldenberg, CEO of the educational toy company Learning Resources, looked at the millions of dollars his firm was paying in new Liberation Day tariffs and saw what he called an illegal executive branch power grab. He sued the president, arguing this was not about national security, but an overreach of authority. He was not a partisan actor, but a business leader fighting what he termed an existential threat. His lawsuit was echoed by retail giant Costco, which took legal action specifically to secure a full refund, fearing the administration would make it impossible to recover the money later. Footwear company Crocs filed suit demanding $54 million back. Even Mexico's corporate titan, Grupo Bimbo, entered the fray, arguing the U.S. was using the pretext of an economic emergency to pressure Mexico on immigration, a use of power it called unconstitutional. These companies were not philosophically opposed to tariffs. They were financially bleeding from what they argued were illegally imposed taxes. This corporate rebellion was soon matched by a constitutional uprising from within the American political system itself. A coalition of 12 state attorneys general, led by New York's Letitia James, filed a separate, powerful lawsuit. Their charge was profound, that the president had upended the constitutional order and brought chaos to the American economy. They argued that the power to levy taxes, and tariffs are taxes, rests solely with the U.S. Congress. By using emergency declarations to impose what amounted to the largest federal tax hike in modern history, the president was bypassing the foundational separation of powers. Their goal was not a corporate refund, but to defend the very structure of American governance from what they viewed as executive overreach. So we have a portrait of a nation challenging itself, American CEOs protecting their bottom lines, and American state officials defending their constitutional system. Their battles converged on a single monumental question now before the Supreme Court. Did Congress, when it passed the International Emergency Economic Powers Act of 1977, intend to give the president the authority to declare trade imbalances or border disputes a national emergency and unilaterally impose economy-altering tariffs? The plaintiffs argue this stretches the law beyond recognition. The administration argues it is a legitimate response to real threats. The court's answer will redefine the limits of presidential power. But while these plaintiffs fight over U.S. law and U.S. money, a nation that is not a party to any of these lawsuits waits as the ultimate collateral target. That is Canada. And here is where the trade economics analysis reveals the trap. Canada's precarious position stems from a critical detail buried in the policy. The very tariffs being challenged, the IEEPA tariffs, contain a life-saving exemption for goods that comply with the USMCA trade agreement. This exemption has been a shield. Data shows it has allowed over 90% of Canadian exports to continue entering the U.S. market tariff-free, preventing the severe recession many predicted. It is the devil you know, but this shield is attached to the very legal weapon being challenged in court. This creates two devastating paths forward, and both are lose-lose scenarios for Canadian sovereignty. In the first scenario, the Supreme Court strikes down the tariffs as illegal. On the surface, this is a win for free trade principles. But for Canada, it is a catastrophic trap. A ruling against the tariffs invalidates the legal mechanism that contains Canada's USMCA exemption. The shield disappears with the sword. And the White House has been unequivocal. Senior officials have a backup plan ready to immediately reimpose tariffs using different legal authorities. U.S. Trade Representative Jameson Greer has openly admitted, yes, short answer, but yes, they can recreate the tariff structure. These new tariffs would be designed to withstand legal challenge, and crucially, they carry no automatic guarantee of including Canada's protective exemption. Overnight, Canada could be forced to exchange a known threat with a carve-out for an unknown threat without one. The legal victory in Washington would vaporize Canada's primary economic defense. In the second scenario, the Supreme Court upholds the tariffs as a legal use of presidential power. This outcome solidifies the weapon rather than removing it. It would formally ratify the use of emergency economic powers as a routine tool of trade policy, giving any current or future U.S. president a green light to use it against Canada or any other nation with minimal constraint. Canada's vulnerability would become permanent, codified into U.S. law. The exemptions it relies on today could be revoked at any moment by a simple presidential decision. The devil you know would be granted permanent legitimacy, its leash entirely in the hands of the White House. This lose-lose paradox is amplified to its maximum effect by brutal geopolitical timing. The Supreme Court's ruling will land precisely as the mandatory high-stakes review of the USMCA trade deal begins. This is not a coincidence. It is a masterclass in coercive leverage. Imagine the negotiating table. Canada will arrive either with its economic shield just shattered by the court's ruling, or with the legal standing of the U.S.'s most powerful trade weapon just cemented by the court's ruling. In either case, Washington's leverage is magnified. It can pressure for concessions on dairy, digital media, procurement, and auto rules from a position of overwhelming strength, using the threat of new tariffs or the revocation of existing exemptions as an unspoken cudgel. Canada's fate in the most important trade negotiation of a generation will be fundamentally shaped by a legal verdict in a case where it had no voice. This moment crystallizes the core trade economics thesis. Canada is the archetype of a smaller, rich, yet structurally poor nation. It is endowed with immense natural resources, human capital, and export wealth. Yet, this material richness does not translate into sovereign power because its economic central nervous system is wired through the United States. Over 70% of its exports flow south. Its supply chains are integrated not as a partnership of equals, but as a dependent spoke to a hub. Therefore, its prosperity is contingent on decisions made in foreign institutions, the White House, the U.S. Congress, and now, emphatically, the U.S. Supreme Court. The drama of the American plaintiffs, the CEO, the state attorneys, the foreign corporation, is more than a legal curiosity. It is the mechanism that exposes Canada's powerlessness. Canada's economic security is being decided in a courtroom where it does not have standing, based on a constitutional debate it cannot join, fought by parties whose interests are not its own. The country can only prepare and react, It can respond, but it cannot decide. It can adapt, but it cannot shape. It can negotiate, but it cannot dictate the terms of its own vulnerability. The Supreme Court case is therefore not merely about tariffs. It is about the architecture of modern power in North America. It reveals that in the 21st century, sovereignty is eroded not just by armies or explicit dictates, but through legal frameworks, the strategic creation of uncertainty, and the ruthless exploitation of structural dependency. As the justices deliberate, they are doing more than interpreting a 1977 statute. They are actively defining the contours of Canadian economic sovereignty. For Canada, the chilling lesson is that its future is being written in the footnotes of a foreign legal battle, a stark reminder that in the shadow of an empire, wealth is no substitute for power, and the rules of the game can be rewritten in a courtroom where you don't have a seat. If this analysis of where real power lies changes how you see the headlines, then you understand the mission of this channel. This is Trade Economics. Subscribe for the deep dives that connect the dots. Hit the bell to see the forces shaping our world. Share this breakdown with someone who needs to see the real game. See you in the next.